Welcome to Mimi Leaks, where we take a look at lawsuits and the stories of high-profile people and celebrities. Today, we're unraveling the civil lawsuit filed by Jane Doe against comedian Russell Brand, Warner Brothers, and others. Before we get into that, let's briefly discuss his other charges. On April 4th, 2025, Brand was charged with multiple offenses in the United Kingdom, all of which allege Brand assaulted his victims by forcing them into indecent acts and assault. Brand is scheduled to appear at Westminster Magistrates Court on May 2nd for the first hearing in that matter. As of today, there does not appear to be any publicly released court documents related to these charges. But I did find another lawsuit in the United States, this one filed by Jane Doe, and it accuses Russell Brand of SA in 2010 during filming of the movie Arthur. Doe alleges that Brand exposed himself and later assaulted her in a bathroom with a production crew member guarding the door. Both Brand, Warner Brothers, and other relevant parties named as defendants all deny the allegations. I typically read newly filed cases, but the civil trial was actually filed in November of 2023. Still, it's very much an active lawsuit with ongoing hearings and motions, and perhaps it will provide insight into what Brand is facing in his UK criminal case. So today, we will break down the allegations and claims against Brand made by Jane Doe. Please keep in mind, this may be sensitive for some viewers, as it describes abuse in SA, and if needed, please skip this episode. Otherwise, hit that like and subscribe button, please, and let's dive in. This is in the county and state of New York with the Supreme Court of the state of New York. It's Jane Doe, plaintiff against Russell Brand, Warner Brothers Pictures, Warner Brothers Discovery, MBST Entertainment, Bender Spink, and Langley Park Pictures. Nature of the claim. This act is brought under the Adult Survivors Act by plaintiff who was abused by defendant Brand on the set of motion picture Arthur, where she was employed as an actor. Plaintiff was SA'd by defendant Brand when he misused the power, fame, and prestige given to him by defendants Warner Brothers Pictures, Warner Brothers Discovery, MBST Entertainment, Bender Spink, and Langley Park Pictures in such a nefarious and horrific way. In performing the SA set forth below, Brand committed multiple torts, including, but not limited to, crimes of an intimate nature and intentional infliction of emotional distress, pursuant to New York common law. Corporate defendants are also culpable and liable because they knew and/or should have known that Brand was acting inappropriately toward women on set, including exposing his private parts, abusing women intimately, and SAing women, but did nothing to stop it. Corporate defendants did not investigate, reprimand, supervise, nor in any way try to stop Brand from SAing, assaulting, and/or battering women on set or involved with the production of Arthur. Moreover, corporate defendants condoned and encouraged Brand's misconduct, abuse, assault, and/or battery of women, including on company premises, by doing nothing to stop it despite knowledge of his inappropriate and abusive behavior on set. Brand's intentional exposure of his private parts on set that day before the SA, and by providing Brand with staff and facilities to aid in his abuse of women on set. Plaintiffs' claims against corporate defendants are liable for their negligence and negligent hiring, retention, and supervision because they knew or should have known that Brand was SAing, assaulting, and battering women on set or involved with the production of Arthur, but failed to do nothing to stop it, investigate it, or protect the plaintiff and other women. As widely reported in the media, there have been numerous other incidents as follows. 4 women allege that Brand SA'd them between 2006 and 2013. One woman alleges that Brand SA'd her while working in Los Angeles. A Channel 4 employee alleges that Brand exposed himself to her in his dressing room and suggested she perform oral acts on him. Another alleges that Brand flashed himself at a woman on a BBC set and it is alleged that some of Brand's colleagues at Channel 4 felt their role was to assist Brand in meeting young women, making them feel like pimps. The following is a summarization of the parties portion, which I will flip through on the screen. Plaintiff Jane Doe was and is a resident of New York. Named defendant Russell Brand, S.A.'d plaintiff in New York, July 7, 2010. The following are also named defendants, corporate defendants, and Brand was an acting representative of the following entities during the relevant time periods. Warner Brothers Pictures is headquartered in Burbank, California. Warner Brothers Discovery is headquartered in New York, New York. MBST Entertainment is a management company in California. Bender Spink is a management company in California. Langley Park Pictures is also a management company in California. The lawsuit not only includes the named corporate defendants, but also any predecessor entities or merged organizations that existed during the relevant time periods. During 2010 to 2011, all named defendants acted as agents of one another, while the corporate defendants owned, operated, and managed the remake of Arthur, filmed in New York, New York. The corporate defendants also financially benefited from their association with Russell Brand and the movie's success. At all relevant times, the employees, agents, and/or servants of the corporate defendants facilitated the SA of women, including plaintiff, by Brand by, among other things, bestowing Brand with power or the appearance of power on the set of Arthur, permitting Russell Brand access to women, allowing him to get drunk while on set or while working on Arthur, allowing Brand to expose himself on set while working on Arthur, failing to send Brand home on the day of the incident, but before the SA occurred, despite his consumption of alcohol, display of drunkenness, and/or exposing himself to the plaintiff and others on set, failing to protect women involved in Arthur, providing locations for Brand to SA women, and implicitly approving and ratifying the SA through inaction or the other actions set forth herein. Facts of the case. In or about 2010, plaintiff was employed as an extra to appear in a scene of the movie Arthur, filmed at Le Cirque restaurant located in New York. The scene was expected to shoot over 3 days. Said scene began filming on or about July 7, 2010. On July 7th, Brand was visibly intoxicated and carried an open alcohol bottle while on set at Le Cirque. Plaintiff was sitting at a table in the restaurant, waiting to begin filming, when Brand made eye contact with her. While he continued to stare at plaintiff, Brand pulled his erect private part out of his pants in an open and obvious manner while directly facing plaintiff. When Brand exposed himself, it was done openly and obviously in the presence of everyone on set, including the employees of corporate defendants. However, no one disciplined, supervised, or reprimanded Brand, protected plaintiff, or the other people present from Brand's inappropriate conduct, or sent Brand home, which would have and should have avoided the SA altogether. Instead, Brand's behavior was treated as acceptable to the defendant's employees on set. Later that day, during a break-in filming, plaintiff entered a stall in the bathroom, believing she was the only person in the multi-stall restroom. When plaintiff exited the stall, Brand was in the restroom, physically blocking the exit with his body, with his pants pulled down and his erect member exposed to plaintiff once again. Scared and afraid, she asked Brand if he was okay. Plaintiff proceeded to wash her hands and pretend that Brand was not exposing himself or blocking her only means of escape, because she was fearful for her safety and for the continuity of this job, given the corporate defendant's employees' prior complacency with and seeming acceptance of Brand's overt misconduct from earlier that day. Brand then walked behind plaintiff and pressed himself up against her backside. Brand then forced plaintiff into a stall and repeatedly asked her to kiss his exposed private part. Brand then pushed plaintiff's head down and forced his private part into her mouth. The forced oral intimate act continued until the plaintiff was able to push Brand away and escape the bathroom. When plaintiff exited the bathroom, there was a production crew member directly outside the bathroom door in a position that indicated that they were guarding the door to ensure that Brand would not be interrupted as he cornered and SA'd the plaintiff. Following Brand's SA of plaintiff was not asked back for the second or third days of filming and was only paid for 1 day of work. Causes of action. The complaint contains 10 causes. 7 through 10 were subsequently dismissed. Therefore, I'll summarize the first 6 causes, and up top, they all state the following. Plaintiff reasserts every allegation contained in all preceding paragraphs. Plaintiff sustained serious psychological injuries, emotional distress, mental anguish, embarrassment, humiliation, and economic losses. Plaintiff has incurred medical expenses and will need to expend sums for medical care and attention. Plaintiff is entitled to compensatory damages in such sums as a jury would find fair, just, and adequate. Defendant Brand's conduct was wanton, reckless, and/or malicious. Plaintiff is entitled to punitive damages in such sums as a jury would find fair, just, and adequate. The amount of damages sought exceeds the jurisdiction of all lower courts, and this action falls within exceptions to Article 16 of the CPLR. The 5th and 6th causes of action are directed at corporate defendants and center on the alleged negligence in handling Brand's misconduct on the set of Arthur. These claims assert that their corporate defendants are liable for the same physical, psychological, economic, compensatory, and punitive damages as those alleged against Brand in the first 4 causes. The 5th cause of action, negligent hiring, retention, and supervision, alleges the corporate defendants knowingly retained Brand despite his inappropriate behavior, including exposing himself on set, intoxication, and aggression towards women. Finally, the 6th cause, for negligence, claims the corporate defendants failed in their duty of care to provide a safe working environment free from predators, disregarding clear signs of Brand's inappropriate behavior, and permitting conditions that facilitate harm. Finally, the plaintiff demands judgment that is fair, just, and adequate, and contains the following: a declaratory judgment, an injunction and order permanently restraining the defendants from engaging in this conduct in the future, and an award determined at trial. The award should compensate the plaintiff for financial and reputational damages, for physical and mental anguish, and all other losses suffered by the plaintiff. Additionally, punitive compensation, costs and attorney's fees, prejudgment interests, and any other relief the court deems proper as well. And that concludes the complaint in the case of Jane Doe versus Russell Brand, Warner Brothers, and other defendants. The corporate defendants and Russell Brand have filed separate answers in this case. Also, it's been recently reported that Warner Brothers will turn over what could be up to 8 hours of footage from the filming of Arthur. This case, like many others, begs the question: what responsibility do studios and employers bear in holding performers accountable for behavior that ranges from offensive and deviant to criminal? And what does Brand's friendship with Sean Combs, or Diddy, another figure facing criminal trials and civil cases, suggest about Brand's innocence, or even his morality? As a reminder, these are allegations. Brand has not yet been found liable for these claims, nor has he been found guilty of any criminal activity. As Russell Brand's legal battles unfold, the public will continue to watch, and the search for accountability will continue. Thank you for watching. Don't forget to like and subscribe, and hit that notification bell to stay updated on this story and others like it. Until next time, stay safe.